Good morning. I'm Ken Moorfield, the manager of the Environmental Management Office for the Department of Transportation here in the central office in Tallahassee. I would first like to thank everyone for attending today's webinar. We do have a record of everyone that registered, and we appreciate that. If any of the folks that have registered have other folks in the room with you today listening to this, we would appreciate an email to Peter McGilfrey, who was the one that confirmed your registration initially. If you could confirm other folks that might have been in the room so that we'll have a complete record of who attended this webinar. Again, Ken Moorfield with the Department of Transportation. I'll be doing the majority of the webinar, but I also have here with me is Buddy Cannell with FHWA, Florida Division, again here in Tallahassee. He will be presenting to you also. And the webinar today is informational. It is for us to give you some insight in the FDOT's application for NEPA assignment from the Department of Transportation, the Federal Department of Transportation through FHWA. We will be talking to you one way today. We will be offering one-on-one meetings with the folks that are on, agencies that are on the webinar today. I'll mention that again later on, but you'll have the opportunity to ask us to have a one-on-one to discuss in more detail. We'll be glad to do that. Again, my contact information will be up on the last slide. You can go ahead and let us know that you would want one. We do plan to contact the folks, the agencies that are on the webinar to see if they would like one-on-one, but if you know you want one, go ahead and request one. The slides and the audio is being recorded for this particular webinar. The slides and the audio will be available on our website, and again, that website is on the last slide that you'll see today, but it's basically going to the FDOT website, going to the Environmental Management Office, and click on the appropriate button. But we will have that available right after the webinar today. So we'll get going, and we'll go to the first page, the second page actually. The first page is just general. What is NEPA assignment? I do not plan on reading all of this stuff. You'll have an opportunity to view the slides later. But basically, the MAP 21 bill, that is the federal highway bill, moving ahead for progress in the 21st century, pretty much outlined the process that states can apply to the Department of Transportation for NEPA assignment. That is not just for highways, but for the transit. You can go through the federal transit agencies, etc. But today we're talking about strictly asking for NEPA assignment by application for the highway program through FHWA. So the formal assignment of FHWA NEPA project decisions are what we're talking about. Project decisions only, not program level. It'll be project level decisions that FHWA is currently responsible for. And again, we're asking for the NEPA assignment for all classes of actions, categorical exclusions, environmental assessments, and environmental impact statements. We would have to comply with all the federal environmental laws, rules, and orders, just as the federal highway does today. Under this program, FDOT would be deemed to be FHWA, the lead federal agency, on all project-level environmental matters. What this entails is that the FDOT must prepare an application, which we have that underway today. We prepare an application, and we're doing that in cooperation with our federal highway partners, the Florida Division. The application obviously will be, and I have some timelines later on, will be sent in to FHWA. From that application, once the application is accepted, the implementation document will be a memorandum of understanding, which will be initially drafted by FDOT, and then we'll work with our FHWA partners to work out any of the details, and then at some point the memorandum of understanding will be executed by FHWA administrator up in D.C. For the Secretary of Department of Transportation. So obviously, when it leaves Florida, it will have hopefully the blessing of both Florida Department of Transportation and the FHWA division. Real quickly, and FHWA will touch on it a little bit later, but FHWA does retain the following. All of the engineering decisions are still FHWA. Project level air quality conformity determinations. Fortunately, currently, Florida is an attainment, so this should not be an issue. All government-to-government tribal consultation will still occur through FHWA. USDOT responsibility for statewide metropolitan planning remains with FHWA and USDOT. Any projects across state lines would not be covered by this agreement. And FHWA does retain stewardship and oversight for this process. And then again, the MOU that we execute will outline what the requirements are for review. Currently, under statutes and in part of the MOU, FHWA will be conducting 2 audits each year for the first 3 years and 1 audit the last 2 years, which surmises it's a 5-year program. So once we get the MOU signed, it's good for 5 years, and then if it's going to be carried on, we would have to renew it at the end of 5 years. Just to give you a little background to show that Florida is not alone out there. Other states are in the process. California was the pilot state. Initially, they've had it for 5 years, and they're currently in their renew mode with FHWA. Texas just recently got theirs the end of, I think it was December time frame of 2014. They just had their executed MOU. And as you can see, Utah and Ohio are pretty advanced in their application. Ohio's is just coming off of the posted with the Federal Register and should be effective fairly soon. Utah has posted theirs. And then you can see Alaska, Idaho, and Florida are actively pursuing this NEPA assignment. The program in Florida, like I said, basically we're requesting all FHWA's project level responsibilities for highway projects, project level in the state. That is all requirements that for NEPA, all eligible federal environmental laws and executive orders, etc., as part of 773, which means nothing to you probably, but that's the implementing language. We'll have to comply with all of that. And again, it's for all the different level classes, EIS, EA, CEs, and LAP projects, local agency projects. The projects that are using federal funds but are off the state highway system or that locals are conducting on the state highway system would go through the local agency process. Those would also be part of this NEPA assignment. And then also, as we develop the application, the MOU, FDOT needs to make an evaluation to accept all projects, no matter what stage they are in approval, or that we leave some on the table with FHWA to continue on to completion. That is part of the application and MOU process that we have to evaluate. What are some of the benefits to Florida? Specifically, Florida would be responsible for the fate of its own projects. We already are responsible for our own projects. What this means is, as of today, our projects that require federal signature authority, I'm using EIS as an example, where they may be signing the final document, it goes up for review to FHWA. Their concerns have to be addressed in order to get the signature on the documents. They have the say-so on whether they approve the changes in the documents. Under this one, on project level documents, it will be internal to the department. It won't be going to FHWA. We have to determine what is or isn't acceptable in the document and whether it complies with the federal NEPA and all the other environmental laws. So Florida would have the decision-making authority, assuming FHWA's responsibilities for project level responsibilities. Now, what this does not mean is any reduction in the environmental oversight in consideration. So there will be no reduction in environmental considerations. We will still be doing a thorough state evaluation to comply with all state laws, and we will be doing a good evaluation, making sure we're complying with all the federal laws, specifically the FHWA requirements and, of course, NEPA. So the bottom line is there'll be a time and cost savings in the review process. And for example, California is already saying they've saved an average of 11 years over the 5 years for their environmental or EIS documents. Texas is projecting a 25% time savings by having these decisions made internally as opposed to going through the federal review process. So it eliminates one layer of governmental review. It allows direct consultation between FDOT and federal regulatory agencies. It consolidates all NEPA reviews under FDOT. Hopefully it's going to give a more timely delivery of transportation projects to the citizens of Florida. More efficient use of FDOT staff and resources. And of course the realized cost savings will be applied to the Department of Transportation's projects that are in the future. And just to give you an oversight for some of you that are on the phone, a snapshot of how the department is organized. We have 7 districts in the Florida Turnpike. A lot of the folks may think that's a separate agency. It is not. It is part of the Department of Transportation. It pretty much operates as a district upon itself, but it reports to the Secretary, just like the other districts. The SEMO, the State Environmental Management Office, is located in Tallahassee. Under this process, the SEMO office in Tallahassee is the group that's assuming the role for FHWA in this NEPA assignment process. The reviews and the approvals and the signature authority will reside in Tallahassee. The districts will continue, as they do today, preparing the documents, submitting for review to FDOT as opposed to FHWA, and it'll be through the SEMO office. So the district's responsibilities pretty much remain the same. There'll be some changes as we'll mention a little bit later on how they document and record certain things, but pretty much what they do and how they do it will remain the same. Again, one of the things that the department has to agree to is that under this we have to assume a legal responsibility and the liability that goes along with approving and signing these documents. Currently, for example, an EIS is signed by FHWA, not FDOT. If there is a challenge in a lawsuit filed in federal court, FHWA is the defendant, so to speak. Under this assignment, the state of Florida needs to take on that role also so that we can, in fact, we'll sign the documents, and then if there is a challenge, FDOT will be the defendant. We have to submit, which we've already filed the bill in the legislature, to assume a limited waiver of sovereign immunity so that it basically allows the state to be sued for these actions only in federal court, and we agree to be sued in federal court. It's been filed, and we've done our homework with the governor's office, the House, and the Senate, so we believe that there will not be a problem there. And the Attorney General also has given the blessing on that. The only nuance is we can draft the application, which we anticipate having the draft done by the end of the year, first of the year for review internally and by FHWA. But the final application cannot be sent in until that bill has passed and we have an effective date out there. Then we can submit the application. So that's the one piece of information that is beyond FHWA and FDOT's control. But like I said, it's been filed, and we anticipate that going through without a problem. And again, I've already mentioned FDOT replaces FHWA as the lead federal agency for highway projects for project level decisions. So the basic result in savings is from a more efficient review process, not shortcutting any of the processes. going over a little bit more of what the role for the Department of Transportation will be. Of course, internally, we'll be responsible for the NEPA Assignment Program and management inside of the Department of Transportation and the oversight to make sure that, in fact, the MOU as signed and the requirements are being followed internally. Again, I mentioned FHWA will be doing audits to making sure that the same thing is occurring from their review. So the Department of Transportation will be responsible for making sure that we comply and that we respond and correct any audit findings that FHWA may find. We are responsible for documentation and records management. As I may have mentioned earlier, we do have a documentation and records management process today. I'd say it's not as uniform as it needs to be, and so we're in the process of updating and changing how the districts will document and store the records that we will need to show FHWA that we have complied with the MOU and that they can report accordingly, and that when we have the audits, the documents will be easily able to be brought up and be reviewed. That also means that we will be updating our quality assurance and our quality control. The quality control is still going to be in the districts and by the consultants they hire to do the processes. We will be overseeing the quality control and sampling through a QA process, making sure that quality control is happening. So we will be documenting that in our application, how we will be doing that. I've already touched on legal. Legal today, FHWA at the near the conclusion of the process, does a legal sufficiency review to make sure that everything has been touched and that the legal is satisfied with the documents. Therefore, FHWA can sign it. We will be doing the same legal sufficiency reviews internally with the Florida legal staff, and that will be done prior to execution of whichever document is in question. We'll also be supporting FHWA audits. When FHWA, the audit requirements are already out there since they've done some in California and Texas. We're aware of what the audits entail. So we will, once we're notified of the audits and what they're going to do and where they're going to go, we'll be responsible for setting up the appropriate districts, projects for review and or staff that they would require to interview. So we'll be supporting them on that. We will not be conducting the audits. We'll just be giving them the documents and then responding to any audit findings. We also have to do training of staff up in the central office and the districts so that they'll understand what is in the application, what is in the signed MOU, and that we will be updating all of our policies and procedures and our manuals. These manuals and policies will do not have to be completed by the time we execute the MOU, but they have to be updated in a 6-month period after execution to comply with what was in the approved MOU. So we'll be doing that. Also, in any agreements that we have out there with you resource agencies that are on the call that refer to FHWA's role on a project level basis, we'll also be updating those in the 6 months after the initiation or the effective date of the MOU. And then over the time period, just like FHWA does, we'll get notice of any changes in federal laws, regulations, anything that comes out of Washington DOT, FHWA will be getting those, and then we'll be passing those on to our districts to make sure that they comply and update our procedures accordingly. Now, our responsibilities, as I've outlined several times, we must comply with the MOU. And the MOU is going to list all the documents and laws and rules of the NEPA, National Environmental Policy Act, that we have to comply with. So by just saying we have to comply with the MOU is going to reiterate all the laws, rules, regulations that we do have to follow. We will be reviewing and approval all the documents. The CEs, Type 2s in Florida, the Type 1 CEs are already in the districts. They approve those. And we just updated our programmatic agreement just recently with FHWA. Those will remain in the districts as they are today. but the Type 2 CEs, EAs, and EISs and LAP projects will be the central office. Again, like I said, we have to consent to being sued in federal court, and we will have to defend those actions in federal court. How will this change the process? The resource agencies, you will be responding as you always have been with the districts on any particular issues. Any issues that you have been going on a project level to FHWA would be coordinated through FDOT at this point. Again, the State Environmental Management Office in Tallahassee will be acting as the FHWA, the lead federal agency in this case, and the issues will be through our office here in Tallahassee. So the program, FDOT solely becomes responsible and liable for all of its decisions. Again, like I said, for an example of an EIS, once the document is approved in the central office, it will be signed by FDOT, not Federal Highway Administration. Processes that we have will be reflected again to change that FDOT is now the lead federal agency. All federal agency and state requirements will be addressed just as it always has been done. With that, I'm going to turn it over. The next slide will be addressed by Buddy Keneal with FHWA, and then when she's done, I will pick up on the next slide.
Okay, thank you, Ken. Again, I'm Buddy Keneal, the Environmental Team Lead with FHWA Florida Division. As Ken mentioned, FHWA supports the NEPA Assignment or NEPA Assumption Program, and we're looking forward to working very closely with FDOT to make sure that this is a successful transition, both in the development of the application and in the MOU itself. FHWA does retain, as Ken mentioned, stewardship and oversight responsibilities under federal law, and that's for the entire Federal Aid Highway Program, as well as for the NEPA process. Stewardship means basically an efficient and effective management of public funds that have been entrusted to FHWA, and oversight would be defined as the act of ensuring that the Federal Highway Program is delivered consistent with applicable laws, rules, regulations, and policies, and that's the compliance portion of stewardship. FHWA retains all NEPA policy and program responsibilities under this program by federal law, and FDOT is assigned, as Ken mentioned, project-level decision-making and NEPA compliance responsibilities under this program, all of which would be defined in the MOU that Ken talked about. Major change really in this program is that FHWA will no longer provide project-level technical assistance to FDOT or to any partnering agencies. FDOT has sole responsibility under this program at the project level for NEPA compliance and for project decision-making. All questions that relate to projects or all project-level decisions will be the responsibility of FDOT by SEMO or by the districts for them to answer and to address. FHWA will not be able to respond to project-level questions. FHWA will be able to discuss higher-level policy and program-related questions and issues with FDOT and agencies, and provide direct technical policy and program questions as well. All FHWA technical assistance will be at the policy or program level to FDOT and partnering agencies, but not at the project level. FHWA will provide training under the various program elements of the assumption or assignment program. And FHWA will also oversee the NEPA program annually, as Ken mentioned, by use of audits, and will also work closely with FDOT to accumulate data and to report to Congress per federal regulations related to this program. FHWA does intend to reach out to all federal and tribal partners to discuss these program initiatives of NEPA assignment and NEPA assumption. And as Ken mentioned, he is the point of contact for FDOT, and I'm the lead for Federal Highway in this program area. And since FDOT is preparing the NEPA application, Ken would like to have all questions and comments go through him, and that's rightly so. They should. This gives one focal point for all comments. However, if you do have questions of FHWA regarding the program, please feel free to give me a call, and my telephone number is 850-553-2224. And with that, Ken, turn it back to you.
Thank you, buddy. Appreciate that. On the next slide, let's talk a little bit about DOT's readiness. Currently, we're reviewing all EAs and EISs in the central office. We've been doing EISs since 2008 and EAs since 2012. So we've got a real good experience on the documents. It hasn't just been the district sending them directly to FHWA. So we're well aware of what some of the issues are. And then for over 20 years, the districts have been completing the minor categorical exclusions, as I know, the third of the type 1s, and we just recently renewed the programmatic agreement with FHWA for those. And then all of that would fall under the NEPA assignment once the MOU is executed. We are in the process of adding environmental and legal staff in the central office. My particular office, we're adding 5 positions to handle the workload, and legal is looking at adding 1 attorney. They already have 2 attorneys reviewing it. They're looking at adding another attorney to handle the legal load. We also have a team of subject matter experts, whether it be social, environmental, or natural, in our office, and we're adding more as we speak. We have consultant contracts in place to assist us in any reviews or any documentation issues that we may have. So we do have resources besides full-time employees. We have consultant contracts in place. We have established state procedures to meet local, state, and federal requirements already in place. We do have relationships with you folks that are on the line today, that be both federal and state. We already have, like I said, a quality assurance tracking and reporting system, but we're enhancing those to be more efficient and effective to handle the NEPA assignment and the auditing requirements that FHWA has. So our standard or our established records retention program is being enhanced. We've already established cross-functional teams statewide that will be looking at scoping, scheduling, and uniformly presenting the requirements for developing our NEPA documents. So we've already done that, and in the process of doing that almost on a daily basis, but certainly annually. And when any particular environmental document is added to our work program, this team takes a look at the scheduling and the scoping of that particular project. And again, like I mentioned earlier, the district's role remains pretty much unchanged, but they will have to comply with some new documentation and retention issues, and assisting with the audits when the FHWA comes to do their audits. We've briefed our districts, we've briefed our executive management. They're aware of this, and we will continue to do that, and we will have a training sessions later on for all of the districts once the MOU has been signed and we have the actual document that we'll be implementing. What are some of the next steps? Well, let's go back a little bit. Our statement of interest, which was required, was submitted to FHWA on September 3rd. We will be engaging the public and agencies to explain the program. First of all, this webinar is the first step in explaining the program to our agencies. As part of the application process, once the draft application is done, we will be required and will advertise in the Florida Administrative Register Also, once the application goes up to, and the MOU is developed, goes up to FHWA, it will be put into the Federal Register also, and we will be responsible for logging in all the comments through both of those efforts and addressing the comments as we received. So the application really identifies the scope of the assignment, what we currently do and how we're currently organized, what our current and proposed environmental review and procedures and tools entail. So we've got to say how we're doing it today, what we're doing, how we're organized, then how we're going to revise the procedures and how we're going to revise our organization. That all has to be in the application. Then we have to outline what our roles and responsibilities are, both state and federal, how and we're going to conduct the training, and then again, what are the resources that we have to bear on this initiative. And I've already mentioned that again, the NEPA MOU will be made available in the Federal Register once it is completed. A little bit more detail on the schedule just to bring you up to speed of where we are. Again, the statement of interest was submitted in. We have bi-weekly meetings with FDOT and the FHWA. Again, that's twice a month. We do have meetings to discuss where we are in the status of the application. We just concluded, I guess, on November the 3rd and 4th, we had to have a NEPA assignment workshop, which was required in the regulations of submitting the application. FHWA from Washington and FHWA Florida Division came over, and we held a 2-day workshop where everything was outlined on what the requirements are, how FHWA will act during the application, the MOU, and the audits, and then what is required of FDOT. So we put that all out on the table so everybody understood. And so we moved on from that meeting to this first webinar, which is the coordination webinar that shows there as with today's date. Then I've already mentioned that we will be conducting one-on-ones as each agency would like to have one. Of course, those are be scheduled specifically with the particular agencies. Our intent is to have the initial draft completed at the end of this calendar year for submittal to FHWA for review during the month of January. The one issue, again, that I mentioned is out of our control is the legislature passing our bill for the limited waiver of sovereign immunity. Of course, they come to town mid-January, and then we don't know when the bill would pass. We put in there 1/29, but that's the date we don't control. So we'll be completing the application. The only thing that we cannot finalize to submit the application formally is that we have to have the bill passed, and it has to have an effective date. And then the AG has to certify that we do have the limited waiver of sovereign immunity. That AG stands for Florida's Attorney General. The Attorney General also has to certify that our public records law is comparable to the federal, the Freedom of Information Act, which it goes beyond, so that's not an issue. We'll be able to get that from the Attorney General. That'll go into our application package. And again, like I said, the notice of public notice of the public notice of the application in the FAR will be sometime in the February to March time frame, depending on when that bill passes. And then we're looking at the final application again sometime in the March time frame. And again, hopefully once we submit the application, and if you go to the next slide, you can see that based on those dates, we will start developing the draft MOU, submit it to FHWA, and then we'll be negotiating with FHWA on the wording on that MOU, and then hopefully by June, July time frame, we will have the MOU ready for submittal to FHWA. Then it would be, obviously, once that's done, it would be put into the Federal Register, and then when that comes back, we would address the comments. Then the MOU would be sent out for signature. Looks like the latter part of next calendar year, Of course, part of the MOU negotiation process is you can have the MOU effective on the date the parties signed it, or you can have it effective 30 days, 45 days after the parties have signed. So that will be part of the process. So it looks like if everything follows the current schedule and we get a law passed expeditiously out of the Florida legislature, looks like the effective date for this will be sometime in the first quarter of 2017, calendar year 2017. So why will we succeed? Well, basically we have an experienced environmental team, both within the FDOT full-time equivalent employees with our consultants. FHWA is very experienced in this too. We have an excellent training program. We'll be revising the training program to hit on what needs to be done to comply with NEPA assignment. Our manuals and processes are already in place. They will be updated to comply with whatever comes out of the MOU process. We will be focusing on QA, QC to make sure the process works. Again, what we as the central office and the ultimate FHWA dedicated staff now will be doing is we want to make sure that we know of any issues and we get them corrected and have them underway to be corrected prior to any audit. So, of course, any new program that comes on board, I would say, once we get assignment, the first year we're going to have some bumps in the road. That's expected. But we do plan to be on top of it and work with our federal partners as they do the independent audit to find and correct any deficiencies that are out there. So we're working jointly with FHWA. We'll be working jointly with you folks that are agencies that are on the line to make sure that this process works. And like I said, we'll continue to improve and adapt as we go. We'll be working in partnership with all of you on the phone, our federal partners, and we'll need to understand and address any concerns you may have. So that gets back to our one-to-one meetings. We'll be asking you if you would like one. If you don't, that's fine, but we'll be always available to answer any questions that come up. If you know you would like to have a one-on-one, please get in contact with us prior to us contacting you. And again, any existing agreements that we have out there with any of you participating agencies will be updated after the MOU is signed. We have basically a 6-month window to get those done. We may be working on those prior to that, because once we have a good idea of what would be in the MOU, we can be working on the draft document. So it's not that it can't be done before the MOU is executed, but we can't do it before the MOU is executed, but it doesn't have to be 6 months either. If we've got it ready to do, we can put it in the works right after the MOU is executed. So this draws us really to conclusion of our presentation today. Again, there's my contact information. We'll leave that on the screen for you. That is the last slide. That's my current address. That's my office phone number, my DOT email address. And again, this presentation, both the slides and the audio portion, will be on the website that you see there. Again, that's just the DOT's normal website. You click on the Environmental Management Office, and then you go to the NEPA assignment. If you do it in steps, if you can cut and paste that one, or you can try to put it in, it should take you right to it. So again, I would like to thank you for being on the call today. I'd like to thank Buddy again for being here. I think both FHWA and FDOT is excited about this opportunity. I think it's going to do nothing but benefit the citizens of Florida, making sure that we got timely reviews and we have identified the issues. We've mitigated them if they do go through the environmental process to be one of the project initiatives. And that the intent, again, is no shortcuts. We're going to be doing an outstanding job in making sure that as FDOT is now the lead federal agency, that we do an outstanding job and that the environmental process will be strengthened. There will be no lessening of the environmental process. With that, I'll conclude, and again, thank you very much. And if you can send an email again to Pete McGilfrey of anyone that may be attending at your site that wasn't registered. Thank you, and have a good day.